Thank you for tuning in to this Synergy InSights webinar titled ERISA, FEHBA, Medicare, and Medicare Advantage Recovery Rights and Insights. I am Teresa Kenyon. I am the Director of the Lien Resolution Department here at Synergy Settlement Services. I am a licensed attorney in California and Kentucky. Prior to joining Synergy, I spent 8 years with the Rawlings Company seeking recoveries on behalf of those health insurance companies. Now I'm on the other side and I work with my team to provide assistance to plaintiff attorneys, and we handle all different types of health liens, and we have over 300 years of experience in battling liens and fighting for the injured party. As the title suggests, today's agenda is going to cover ERISA, FEHBA, and Medicare. So we'll talk about Medicare A and B, and then we'll also talk about Medicare C and D. This is technically a part 1, and part 2 will have a future blog and a future webinar where we'll cover Medicaid, military, and hospital liens. So in perhaps every webinar that I have ever presented, I always talk about the recovery vendors. These are the people, the companies that you are dealing with as a plaintiff attorney when you are trying to obtain a lien, get a lien reduced, to get a lien waived altogether. And so there's some big ones. There's the big recovery players. That's Optum, Equian, which are now merged, which is its own problem as far as actually getting responses and getting liens and files opened. Conduent, Rawlings Company, Blue Cross Blue Shield in every state. Some of them have internal units and some of them are handled by these recovery vendors. Humana is similar. And then there's also various defense firms that are working on behalf of these health insurance carriers. Now, one thing to know is that they are highly trained. They are trained, though, with very narrow arguments that suit their side. So often, if you have a creative or perhaps outside the box argument that could very easily be read into the ambiguity that exists in the space, the people that you're talking to are going to think that you're crazy because they've been told which way is the right way. So that becomes a problem and often a source of frustration. They also have form letters. So again, you could have that creative argument, you could put it forward, and what you get back is not at all responsive to what you put out. The people that are handling the files have very limited authority to reduce on their own. They often have to have it approved by a manager or somebody else in their company who looks at all the different facts and all the different information that you have given to decide whether a waiver or reduction is warranted in that particular case. In some situations, these recovery vendors have to actually go to the health insurance company to get that authority. So really depends on lots of different factors on whether you'll be able to get a reduction quickly or not. And one thing to really know is that the people that you're talking to are incentivized by their own bonus. It's not all the companies, but it's most of them. And that definitely makes them not want to reduce, because for every little bit that they reduce, it takes away part of their paycheck for their next bonus. They're also incentivized by not being reprimanded. So many of these companies are run with somewhat of an iron fist, very black and white, must do this if this happens. And so they have to make sure that they're checking their boxes. And so again, with that, you might not get the responses that you're looking for. You might be asked for information that you don't think needs to be provided. But that's just the way that these companies are run. And really, these companies handle various lien types. So you really got to make sure that you know what it is that you're talking about. So these companies will handle ERISA liens and non-ERISA liens, Medicare Advantage, Medicare Supplement, FEHBA, Medicaid MCO, which is not traditional Medicaid, but an HMO version that is handled by private health insurance carriers. So just a lot to know when you're starting to think about who it is that you're interacting with on the other side. So first up, ERISA liens. Let's take a look. And when you get told that this lien is for an ERISA plan, you've got to really take a look at a couple different things. And really, you're taking an assessment of the plan's rights to recover. Just because it's an ERISA plan doesn't necessarily mean that they have a right to recover. or that they have a right to recover in full. So you want to take a deep dive and make sure that you're looking at all the right things. So what do you need? You need the plan documents. So ERISA plans are governed by their contract, their policy language. So you want to make sure that you are obtaining it and reviewing it and comparing it and all of those things. So most of the recovery vendors will send you a couple pages of the subrogation section of an SPD, the summary plan description. You want the whole thing because there's parts in it that refer to other parts and refer to other documents and other things that you definitely want to be taking a look at. You also want to be getting the master plan document, the MPD. Not all plans necessarily have a master plan, but you want to do a thorough investigation, reviewing that SPD to see if it refers to another document, another master plan document, because the master plan document is the actual document that controls. Now, it can incorporate other documents by reference, but you got to have all the documents and you got to look at all of them before you are able to assess whether that's actually what's happening in this particular case or not. So every ERISA plan is different because every policy language is different. Another good thing to obtain is the IRS Form 5500. This has a couple relevant boxes that can lead you in the right direction on whether, first of all, whether it is an ERISA plan at all, because only ERISA plans have to file these. Secondly, you can see if it is indicating that it is a fully insured plan or a self-funded plan, and we'll talk about the importance of that in the next slide or two. You also want to be getting the claim summary. So this is what is the breakdown that equals the lien amount that they are claiming that they have a right to recover. You want to make sure that these have the proper billing codes. So these are ICD codes and CPT codes. CPT is for the procedure. So sometimes the ICD code will be very generic. It might say back, but when you look at the procedure code, it says something about the thumb. And if thumb is not part of your case, then that's not something that should be part of the lien. So those CPT codes are very important. Same with the provider names. The dates, if you see a date range, you want a breakdown. If you see bundled charges for a range of dates or for a particular surgery in one lump sum, you want to ask for that breakdown because that's going to give you the nitty-gritty on whether all of it should be included or not in this lien. And then you also have to understand the applicable law. So which law applies, the state law that might be more limiting to their right of recovery, or federal law, which will point to that policy language as the governing law. So if you are dealing with an ERISA plan, you want to make sure that you know what an ERISA plan is. So ERISA basically governs employer-employee health benefit plans. So that is almost all employer provided benefit plans, but it's not going to include religious employers or government employers. So I've got a couple examples here: City of Minneapolis, the County of Ramsey, the State of Minnesota. Federal employees, they are governed under something that is not ERISA. ERISA also doesn't govern government plans like Medicare and Medicaid. And it also doesn't cover individual plans or private plans that are obtained through Obamacare, through the marketplace, with the Affordable Care Act, or through a health insurance broker. So if you've determined that it is an ERISA plan, the next question is its funding status. So is it self-funded or is it fully insured? And on their face, they both look the same. So in both situations, your client is going to have a health insurance card, and it is going to say Aetna or Humana or Cigna or any big insurance company. But the tricky part that you're trying to get to the bottom of is where the money comes from to actually pay those medical claims. So for a self-funded ERISA plan, the employers collect premiums from the employee's paycheck, but those funds, instead of going to an insurance company, are held in a separate account. And then the insurance carrier receives bills from providers, just as you would normally expect, but instead of Cigna or Humana paying the claims out of their own bank account, they're essentially accessing that self-funded account through that specific employer. And that employer is the one who is actually paying for the benefits. Compare this to a fully insured plan. In that situation, the employer collects premiums on the paycheck just as they do on a self-funded plan. But in that situation, they take those premiums and they pay as a premium to Cigna or Humana or Aetna for coverage for their employees. And they themselves, the employer, is no longer financially responsible for the actual payment of the claims. They just have to pay that premium. This is an important distinction because the self-funded plan preempts state law, and then that policy language really governs, whereas a fully insured plan is subject to state law, which is often very limiting, might require a reduction for attorney's fees, might state that they're not allowed to recover at all if the injured party is not made whole, might say that there need to be reductions because of comparative fault or other kind of equitable doctrines. So this is an important piece to dig in on. So I've mentioned that policy language, the contract, a couple of times, and it is this U.S. Supreme Court case of McCutchen, U.S. Airways versus McCutchen, that made that be the case. So essentially, the U.S. Supreme Court decided in 2013 that equitable theories like the made whole rule and the common fund doctrine or reduction for attorney's fees cannot override the clear language of the policy between the ERISA self-funded plan and its member. So what this means is that if a plan clearly states that it's not going to reduce due to the made whole rule, then it doesn't have to reduce for the made whole rule. The flip side of that is that if it doesn't say anything about the made whole rule, and if the state otherwise requires it, or if just in general equity requires that the plan not recover because of made whole, then that deficiency of the policy language is damaging to that health plan's right of recovery. So this particular argument for McCutchen goes both ways. Now the McCutchen case turned many different ways, but this is a quote that I think is a good takeaway. So essentially, third-party recoveries do not often come free. To get one, uninsured must incur lawyers' fees and expenses. Without cost sharing, the insurer free rides on its beneficiaries' efforts, taking the fruits while contributing nothing to the labor. Now, I've mentioned the contract language, and you might be wondering, how do I get that? Especially if all that I'm being provided is 2 or 3 pages of a subrogation section. One, you can certainly demand from the recovery vendor that you get the full document. The other more appropriate way for you to get it is straight from the horse's mouth, which means straight from the employer themselves. And so there is an ERISA document request that is in the ERISA statute. It's 1024B4. And the ERISA statute had an original intent to make sure that the plans disclosed information to the plan's participants. So that's where this request is allowable. Essentially, if you send a written request to the plan administrator, who is the employer, then you should be able to obtain the summary plan description, the master plan document, and a handful of other documents. There is a penalty for the plan's lack of disclosure of these documents after 30 days. So they have 30 days to provide them, and then after that, a penalty begins to run. It's $110 per day, and it can certainly be built into your negotiations, or you can file a separate action against the employer to obtain this penalty. So let's move away from ERISA liens and talk about our next lien for this webinar, which is FEHBA lien. So this is for federal employees and the health plans that are provided to them. So the main thing to know about these FEHBA plans for federal employees is that they preempt state law. So 2017 was the pivotal case for that, where the U.S. Supreme Court in Coventry Healthcare versus Nevels confirmed that Missouri's anti-subrogation law was preempted by FEHBA, by the Federal Employee Health Benefit Act. One thing to note with these particular plans is that most of their policy language is similar. Different agencies, whether it be IRS or CIA or any of the federal agencies that are providing these benefits, there's some variation. Some of them provide discretion, and that's going to be the key for you getting a reduction on these. The discretion is if the injured party had to pay for attorney's fees, and if the injured party is not made whole, then these plans are supposed to provide discretion. But again, you go back to those recovery vendors who are very interested in getting their bonus, and they don't think they have to use their discretion, but that is very much what is built in and written into these FEHBA contracts. So the recovery right for Medicare is statutory. It is under the Medicare Secondary Payer Act, and it provides that primary plans should be the primary payer and that Medicare is the secondary payer when there's somebody else who should be paying. Essentially, Medicare will make a conditional payment when the primary payer can't immediately make payment. And the condition that makes it a conditional payment is that Medicare is entitled to the right of recovery, to be reimbursed. So who do they have a right to recover from? Pretty much anybody. So statutorily, CMS is able to recover the conditional payments that they've made from a primary payer, a beneficiary, a provider, a supplier, a physician, an attorney, a state agency, a private insurer that has received a primary payment, essentially anybody who should have paid or could have paid instead of Medicare and is in receipt of funds for that particular payment is somebody that Medicare can recover from. So Medicare has the ability to seek reimbursement for those conditional payments, which take priority over any other payer. So they've got a priority right, and the Medicare Secondary Payer Act also gives Medicare the right to seek double damages for their conditional payments if those conditional payments are not reimbursed. So this is an important piece for attorneys who maybe receive settlement funds and then don't reimburse Medicare. Medicare could look to you and then not only require that initial reimbursement, but double that amount. So under the statute, it is stated that Medicare may not pay for medical expenses when the payment has been made or can reasonably be expected to be made under a work compensation plan, an automobile or liability insurance policy, or no-fault insurance. If responsibility for the medical expenses is in dispute, such as for a liability plan or a workers' compensation plan, or maybe no-fault insurance that's doing investigation, and the payment won't be promptly made to those providers who have provided service, then those providers can bill Medicare, and Medicare will pay conditionally under the understanding that they will receive the reimbursement once there is a settlement, a judgment, or an award where that primary payer has then issued funds. So for traditional Medicare, for Parts A and B, the BCRC, which is the Benefits Coordination and Recovery Center, is the entity that's responsible for getting Medicare repaid. A conditional payment is the payment that Medicare makes where somebody else might be responsible for paying. Medicare makes this payment so that the Medicare beneficiary doesn't have to use their own money to pay for the bill at the time of service. So as previously stated, Medicare shouldn't be paying for claims when there's somebody else who should be paying it. But in this situation, they will pay it because they don't want the beneficiary to have to pay it out of their own pocket. And then that's what makes it conditional, because Medicare is to be repaid once there is a settlement on the underlying case. Now, traditional Medicare does automatically allow for a reduction of their interest by procurement cost. And there are two different ways that this is looked at based on the lien amount compared to the settlement amount. So if the Medicare amount is less than the settlement amount, then the Medicare interest shall be reduced by procurement costs. If the Medicare payments are the same as or more than the settlement amount, then Medicare will allow the procurement cost reduction off of the settlement and then take the rest. And essentially that means that the Medicare beneficiary gets nothing. That's a horrible result. Luckily, you can go back to Medicare at a later time and ask for a refund, but on its face, that is what the final demand will be. So when it comes to dealing with Medicare, with CMS, you have to interact with the BCRC, and they have a portal, which makes things a lot easier. So just wanted to highlight the types of things that you can do with the portal. So Synergy definitely uses the portal for efficiency's sake. If you are doing any Medicare conditional payment reimbursement in your office, hopefully your office is also using the portal. So essentially, you can submit your proof of representation, or POR, and then also a release or HIPAA through the portal. You can also request the conditional payment information. So this will allow you to see the amount and also the breakdown of what charges are included in that conditional payment. You can dispute claims that shouldn't be part of the conditional payment, claims that are maybe not related to your loss. And you can also initiate a demand letter. So once the case has settled, you can go in to the portal, enter the settlement information, and obtain that final demand amount. You can see what the status is. You can see what documents have been sent. As I just stated, you can submit the settlement information, and then after the final demand has been issued, you can submit waiver and compromise and redetermination request through the portal. So it's definitely very convenient. So let's go ahead and shift our attention from Medicare Parts A and B to Medicare Parts C and D, which is the Medicare Advantage plan and the Medicare Prescription or RX plan. Now these Part C and D plans for Medicare Advantage and Medicare prescription plans are administered by the private health insurance carrier. So you're going to see Aetna and Humana and Blue Shield and Cigna administering and paying claims for these. These are still really critically important for you to identify and to make sure that they are being reimbursed, because statutorily they have the same rights as traditional Medicare to recover. And as previously stated, the Medicare Secondary Payer Act allows for double damages if the Medicare Advantage or Medicare prescription plan are not reimbursed, if their conditional payments are not reimbursed. So certainly something that you want to be asking your clients if they have a Medicare Advantage or Medicare RX insurance card, if they've got any kind of private insurer, because they might just say they have Medicare. And here at Synergy, we can certainly check with Medicare, and we will see if Medicare shows that they are a beneficiary and that they have paid claims, but sometimes we see that they haven't. And what that is an indicator to us that there might be a Medicare Part C plan that has paid for benefits. And then we've got to figure out how we identify who that particular carrier is so that they can be put on notice and that their reimbursement right is taken care of. Now, we didn't talk in detail about how to get reductions from Medicare A and B, aside from the procurement cost reduction. So let's look at the same idea for these C and D plans. Now, really, your pursuit of a reduction with these C and D plans are going to be different than the pursuit of a reduction on the A and B plans. And as you recall, the A and B plans are handled by the BCRC. It's a lot of letters. But these C&D plans are handled by the recovery vendors, those same recovery vendors that handle those ERISA plans and the FEHBA plans and the Medicaid HMO plans. And because of that, they're not familiar with what traditional Medicare actually does. And instead, they're more guided by what a private health plan does or doesn't allow. So that's a challenge all on its own when you're handling these C&D plans. But nonetheless, Medicare C&D has the same right as Medicare, but they also have the same liability. And what that means as far as liability goes is a reduction for procurement costs. So most of these C&D plans will refuse to reduce for procurement costs. And in my opinion, it's mostly just out of ignorance, not realizing that that is something that they have to do. If they are the same as Medicare, then they have to do the same as Medicare. But there's so many places where they don't do the same as Medicare. Nonetheless, you should certainly be getting a procurement cost reduction. You should also, just the same, be auditing the claims for relatedness. Perhaps there's some other insurance carrier that paid, because this Medicare Advantage plan is also a secondary payer. These Medicare plans through private insurance carriers have policy language. So similar to the ERISA and the FEHBA and the other plans that have contract language that guide them, these plans do as well. Now, some of these recovery vendors will very specifically point to that policy language, which then says they don't have to reduce for attorney's fees. That doesn't necessarily mean anything, but nonetheless, you should try to get this policy language. One big reason why you should get the policy language is to make sure that it's actually a Part C or D plan, the Advantage or the prescription, because it could be a supplemental plan or a Medigap plan, which does not have the same rights as Medicare Parts A and B or C and D. So those are certainly things that are important to take a look at when you're looking at these Medicare Advantage and prescription plans with these private insurance carriers. Nonetheless, standard negotiations should be brought. Equitable arguments, hardship arguments, all of those kind of things are still certainly applicable, and it's something that Medicare takes a look at on the back end when they look at issuing refunds. And that's it. This concludes our webinar about ERISA, FEHBA, traditional Medicare, and Medicare Advantage and prescription plans. So if you would like to talk to us further, please give us a call, check out our website, and remember that there is a part 2 that's going to cover military, Medicaid, and hospital liens that'll be coming shortly. Stay tuned.